Hi, I'm Jay from Personal Bar Prep, and this is Simplified, our series designed to simplify difficult concepts on the California bar exam. Today, I want to simplify products liability. So let's get started. Products liability is a favorite of the bar because it allows the bar to use a very short fact pattern in order to test on a lot of tort theories. What do I mean by that? Well, when you have a products liability question, pretty much what you have is this. Some manufacturer or seller of a product is selling a product that causes harm to a third party, ultimately the plaintiff, and that harm was a foreseeable result of taking the product. Where you have that problem, you have a products liability issue. And products liability allows you to discuss the following torts in detail. It allows you to discuss strict liability, negligence, battery, misrepresentation, and breach of the 2 implied warranties and the 1 express warranty. And so what you have is a situation where you're looking for a manufacturer or distributor of a product, that product is somehow or other defective, meaning it doesn't live up to its standards. And as a result, that defect has caused harm to a foreseeable plaintiff. If you have that situation, you have a products liability problem. So first, let's talk about the proper defendants. Anyone in the line of distribution is a proper defendant. Remember, you must be in the business of making or selling the product. Doctors prescribing drugs are not in the business of selling drugs. They are not a products liability defendant. Nor is someone holding a garage sale selling their old chainsaw. They are not in the business of doing that. That is not a products liability problem. What we're looking for is a company that makes the chainsaw or a company that sells the chainsaw, okay? Or it might be pharmaceuticals or what have you. Okay, that's what we're looking for a proper defendant. Proper plaintiff, any foreseeable user or victim. Could be the child of the person who buys the defective car and that child's in the passenger seat and gets hurt by the defect. That's a foreseeable user, and that would be a proper plaintiff. And then finally, you have to show some kind of defect. Defects will fall under 3 categories. There will be a manufacturing defect, which means this particular one was made poorly. There will be a design defect, which means every product made using this design is defective, or there will be a warning defect, meaning there was some known or knowable harm associated with the use of the product and the manufacturer failed to warn about that harm. All 3 of those are actionable defects. You have those things combined, you have a products liability question. Now the question is, how do you resolve it? The plaintiff is going to sue, and they're going to tell you the plaintiff is suing the defendant for products liability. What are they actually arguing? Well, they're arguing that number 1, the defendant is strictly liable. Strict liability for terms of product liability means that the defendant, we'll call him the manufacturer, had a duty to make a reasonably safe product. It's an absolute duty to make a reasonably safe product. And by selling it in its defective state, it was not safe and thus they've breached. Sounds a lot like negligence, but it is not. And the reason it's not is because there's an absolute duty to make it safe. And the way you determine it's not safe is you apply one of 2 tests. Either you're going to use the consumer expectation test, which is what you're going to use during a manufacturing defect problem, and that merely says that the product is more dangerous than an ordinary consumer would reasonably expect. Under the use utility test that we're going to use for design defect and warning defect, you have to show that the risk of harm plus the gravity of harm is greater than the usefulness of the product plus the cost of making it safer. So if it's a simple warning, clearly the design defect will be a breach. And that's why you want to look for warning defects. They're easier to prove. If you've established those 2 things and then there's damage and causation, we have strict liability. The next question is whether or not they are negligent is the defendant negligent? What we're looking for is, did they owe a duty to the plaintiff, to this particular plaintiff, rather than a broad duty, which we find in strict liability, which is to make the product reasonably safe. Now, why is there a duty owed to this plaintiff? And it's because she is foreseeable. Next question is, did they breach their duty? Did they act as a reasonably prudent manufacturer by failing to warn, for example? The answer would be no. A reasonable manufacturer would warn of any known dangers. Then you ask yourself, is there actual cause and proximate cause, meaning but for the defendant's action, the plaintiff would not have been hurt. That proves the but for or the actual cause. And proximate cause is that it's a foreseeable harm to a foreseeable plaintiff. And then once you've established that, show the damages. Next, we can go to battery. Battery is a voluntary act with the intent to cause harmful or offensive touching. Well, the voluntary act is selling the defective product. The hard part is showing intent to cause harmful or offensive touching, because generally manufacturers of products do not desire their clients to be injured from the product. And so you cannot show that they desired the result, which is one way of showing intent. The other way of showing intent is to show that they knew it would occur to a substantial certainty. So what you're looking for is remote risk. The risk is remote, then they did not know it would occur to a substantial certainty. Then we have the theory of misrepresentation. That requires that the manufacturer or someone, the defendant, make some affirmative statement regarding the safetiness of the product that is relied upon by the plaintiff to their detriment, and that reliance was reasonable. If you can show that they advertise it's the safest pill for allergies, and this allergy pill makes you go blind, and you saw the ad on television and you relied upon the ad, then you have an action in fraud or misrepresentation. And then finally, we have the three theories concerning warranties. We have the express warranty, which merely says if there is an expression as to the safety of the product made by the manufacturer or anyone else in the line of distribution, and that statement formed a basis of the bargain, and it was false, there's a breach of the express warranty. Manufacturer sells allergy pills, they claim they're safe. They're not safe, they make you go blind. That's a breach of the express warranty so long as the buyer of the product or the plaintiff was aware of the ad. And in the bar exam, they were. Finally, you have the two implied warranties. There's the implied warranty of merchantability and the implied warranty of fitness for a particular purpose. The implied warranty of merchantability is an objective test that says that the product is both safe and reasonably fit to do what the manufacturer says it will do. If it's an allergy pill and it makes you go blind, I would argue it is not reasonably fit or safe to do what it's supposed to do. And fitness for particular purpose occurs where the manufacturer knows the reason you're buying it and they sell it to you. They are claiming it is both safe and effective for that purpose. If it turns out that it's not safe, that's a breach of their warranty. The allergy pills neatly fit into all three of those. Okay, so remember, what we're looking for, a manufacturer of a defective product that harms a foreseeable user. If you have that, now what we're asking is the manufacturer strictly liable? Are they merely negligent? Have they committed a battery? Have they committed misrepresentation? Or have they violated any of the three warranties? That's the crux of a product's liability question. Always look for the proper plaintiff, proper defendant, a proper defect, then go through the various theories of tort, and you'll resolve the problem. If you enjoyed this video, please leave a like or share it. And if you still have questions about products liability or there's something else you'd like me to go over, just leave a comment and we'll get to it. Our company, Personal Bar Prep, is the small group bar review for the California bar exam. If you like this video, I assure you you'll love the course. You can find a link to our website with more information in the description below. Thanks a lot for watching.